on the matter. Article 145, subarticle 7 of the Constitution provides as follows, I quote, if at least 2/3 of all the members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. This provision speaks to the finality of the Senate's resolution once it upholds an impeachment charge. Upon such resolution, the President or Deputy, as the case may be, stands impeached and ceases to hold office. The constitutional text is categorical that the cessation of office is automatic and does not require any further act of implementation. The impeachment resolution, once validly passed by the Senate, is self-executing and a fait accompli. The constitutional design is deliberate in this respect. It does not envisage an instance where the impeached president or deputy president may be reinstated within the framework of the presidency. The vacancy resulting from the impeachment resolution can only be filled through the procedure under Article 149, subarticle 1. Even in the unlikely event that Parliament and the President wish to return the impeached office bearer, such a cause will still be subject to the availability of the vacancy and the nomination process prescribed by the Constitution. To hold otherwise presents profound constitutional and practical difficulties. The office of the Deputy President is not merely a matter of judicial declaration, but is intertwined with constitutional processes, political accountability, and the functioning of the executive. To order a statement in circumstances where the vacancy has already been filled would amount to the court usurping powers reserved to the people and their representatives under the Constitution. It would upset the delicate balance of separation of powers and create a constitutional absurdity. For the Constitution does not envisage two serving deputy presidents at any one time. The court cannot undo what the Constitution itself declares to be conclusive. Reinstatement, therefore, is not a viable or appropriate relief in the circumstances of this matter. Before leaving these subjects, we find it necessary to acknowledge and comment on the doctrine of constitutional dilemma that arises in these proceedings from the tension between the constitutional finality of impeachment and the vindication of rights. This tension is highlighted by the comparative jurisprudence, most notably in the United States, where courts have adopted a principle of total avoidance, treating impeachment as non-justiciable. Yet our own constitutional framework demonstrates that avoidance cannot resolve the question that persists. In view of the recurring tension, a constitutional amendment clarifying the scope of impeachment finality and the role of judicial review may be warranted. At this juncture, we also find it necessary to distinguish the process of removal of a county governor from that of the president and the deputy president. To begin with, Article 181 of the Constitution sets out the grounds upon which the county governor may be removed from office. They are gross violation of the Constitution or any other law, B, serious reasons to believe that the governor has committed a crime under national or international law, C, abuse of office or gross misconduct, and D, physical or mental incapacity to perform the functions of the office. Article 181, subarticle 2, assigns Parliament the responsibility of enacting legislation to provide for the procedure for removal of a county governor. That legislation is the County Government Act, which we'll be referring to as the County Act in this discussion. And Section 33 thereof prescribes the detailed procedure. It provides for initiation of a motion in the County Assembly, transmission of the resolution to the Senate, investigation by a special committee, the governor's rights to be heard, and ultimately a vote by the Senate delegations. If upheld, the governor ceases to hold office. If rejected, the motion may only be reintroduced after 3 months. When this process is juxtaposed with the removal of a president and deputy president, and Article 144 and 145, several key differences